good enough to go get a hunt him down, track him down, and kill him.
With the help of their mother.
Exactly.
You are hereby sentenced to death. As you tightened the cord around her neck, she was aware that she was losing her ability to breathe.
You will see that Clive Phillips is a monster.
Fidel Lopez and Maria Nemeth had recently moved into a new apartment in Sunrise, Florida, where they hoped to start a new chapter in their relationship. On the night of September 19th, 2015, they spent the evening drinking and relaxing together. During an moment, an argument broke out after Lopez claimed Maria mentioned her ex-husband's name. This emotional reaction led to a destructive outburst, with Lopez causing significant damage inside their apartment and assaulting Maria. Shortly afterward, he called 911, reporting that Maria was unresponsive. When first responders arrived, they found clear signs of distress and damage throughout the home. At first, Lopez told police that what happened was accidental and part of a consensual encounter. However, inconsistencies in his story led to further investigation, and he eventually admitted to losing control during the argument. In 2017, Lopez accepted a plea deal to avoid the death penalty and was sentenced to life in prison without the possibility of parole.
In this case, the photos and the video are extremely graphic. We don't want the family to have to relive some of that, the photos and the video. And there are other independent witnesses, a medical examiner and law enforcement that were on the scene that can provide that testimony without exposing the jurors to that trauma.
In later hearings, discussions focused on whether graphic material should be shown in court, given the sensitivity of the case, with prosecutors acknowledging the footage was highly disturbing. Changes in state law also meant Lopez could not face capital punishment, even if retried. In 1990, the body of Lázaro Figueroa was found in a Miami Beach neighborhood, sparking one of Florida's most disturbing cases. The boy showed signs of long-term neglect and suffering. His mother, Ana Maria Cardona, was arrested shortly after and charged with first-degree murder and aggravated child abuse.
I do know that regardless of what your faith is, you will not be meeting Lazarus in the afterlife. Your actions were monstrous. My mind recoils at the hellish existence you put Lazarus through that last year of his life.
Cardona claimed she was innocent and her partner, Olivia Gonzalez, was responsible, but prosecutors believed otherwise and pursued the case against her.
Yo no maté a mi hija.
I did not
Yo
kill
no
my
torturé a mi
I did not
hijo.
torture
Yo
my
no
son.
abusé de mi hijo. Quizás usted no me cree.
Maybe you don't believe me.
Usted no me puede, o quizás usted no sienta mi dolor.
Maybe you don't
Nadie
feel my
puede amar
pain.
más a mi
Nobody
hijo
could
que yo.
love.
Over the next 3 decades, Cardona faced 3 separate trials. Her first 2 convictions in 1992 and 2010, both resulting in death sentences, were later overturned due to prosecutorial misconduct and improper arguments.
There are wild beasts that show more empathy for their offspring than you showed for Lazarus. And the jury, having found you guilty on count 1, I sentence you. I adjudicate you guilty. I sentence you to life in prison.
In her third and final trial in 2017, prosecutors opted not to seek the death penalty. The jury found her guilty in under 4 hours, and Cardona was sentenced to life in prison, plus 15 years for child abuse, closing a painful chapter in Florida's legal history. In 2014, Nathan and Benjamin Curry, 2 brothers from South Florida, were involved in the tragic killing of 41-year-old Lonnie Reese. The incident began when the brothers falsely accused Reese of stealing an AK-47 rifle from their mother. Driven by anger and suspicion, the brothers tracked Reese down and confronted him near Northwest 29th Avenue and 46th Street in Miami. During the confrontation, Nathan allegedly urged his older brother, Benjamin, to pursue Reese, leading to Benjamin Reese. Reese later died from his injuries.
He was falsely accused, and it seemed like they tracked him down.
They hunted him
They
down.
hunted him.
Yes, they followed him.
In other words, they were stalking him. They were standing in my window watching
That's the
him
grandmother.
every move he made.
The case became a focal point for discussions on juvenile justice, as Benjamin, who had a history of juvenile offenses. Both brothers were arrested and charged with first-degree murder.
I don't know what it was, but I don't know why they felt as though it was good enough to go get a hunt him down, track him down, and kill him.
With the help of their mother.
Exactly. Y'all can find her and ask her what was she thinking as far as being a mama to them 2 15 and 16-year-old boys.
In May 2016, the trial concluded with the convictions of both brothers. Nathan Curry was sentenced to 30 years in prison for second-degree murder, while Benjamin, who was convicted of first-degree murder, was sentenced to life in prison without the possibility of parole. In 2000, twins Nubia and Victor were born in Washington state and placed into the foster care system due to instability in their biological family. After a series of temporary homes, the twins were placed with Jorge and Carmen Barahona in Florida. In 2009, despite earlier concerns from school staff and doctors about possible neglect, the Barahonas were granted full adoption of the twins. Reports of Nubia's health problems, including extreme weight loss and missed appointments, were often dismissed or attributed to illness rather than signs of mistreatment. On February 14, 2011, a call to authorities led to a tragic discovery along I-95 in West Palm Beach. Jorge Barahona's vehicle was found parked on the roadside. In the truck, Victor was found in distress with visible injuries, while Nubia was tragically found deceased in the back of the vehicle.
Can't get any worse than this. Some of the atrocities that we see here are just they're heartbreaking.
A full investigation followed, uncovering evidence of long-term mistreatment.
That his father used to pour hot sauce in his ears, eyes, nose, and mouth. His father made him eat a cockroach.
Both adoptive parents were arrested and charged. For nearly a decade, both maintained their innocence.
You would enter a plea of guilt in this case, is that correct? Yes. Now, at this time, you're entering a plea of guilt to all counts in the indictment that apply to you. Is that your understanding?
In 2020, Carmen Barahona pleaded guilty to her role in Nubia's death and agreed to testify against her husband as part of a plea deal. She was sentenced to life in prison without parole. As of 2025, Jorge Barahona's trial remains pending due to repeated legal delays. In September 2013, Clive Dalton Phillips returned unexpectedly to his home in Albuquerque, New Mexico. There, he found his ex-girlfriend, Alexandria Bull, who was also the mother of his daughter, alongside their roommate, Adrian Carriaga. The situation quickly turned tense. Overwhelmed with emotion, Phillips confronted the pair. According to court records, what followed was a serious altercation. Both Adrian and Alexandria were harmed during the incident, with Adrian tragically losing his life and Alexandria sustaining significant injuries. Phillips was arrested and charged with multiple offenses. At trial, a jury convicted him on several counts of aggravated battery. However, they could not reach a unanimous decision on the murder charge, resulting in a mistrial on that count. In early 2018, Phillips agreed to a plea deal and admitted guilt to voluntary manslaughter. During the sentencing phase, the courtroom was filled with Adrian Carriaga's mother. Cheryl Carriaga urged the judge to impose the full sentence.
But I pray you will see that Clive Phillips is a monster. He's a manipulative and evil man.
Judge Whitaker sentenced Phillips to 25 years in prison, suspending 7 years, leaving him with an 18-year prison term. Phillips appealed. In 2024, the New Mexico Supreme Court upheld Phillips' convictions, ruling that each act of violence was a separate offense and did not violate double jeopardy laws. In early 2016, Danielle Jones, a 23-year-old Miami woman, posted an ad on Craigslist seeking a roommate. She soon connected with Byron Mitchell, a 39-year-old Air Force veteran and personal trainer. After meeting him in a public space and reviewing his background, Jones felt it was safe to let him move in.
At first, I wasn't really sure because, it was a guy, and I didn't think, living with a guy was a very smart decision. But then at the same time, I was like, rent is almost due. I'm going to lose my home. I'm going to get evicted. That'll ruin my life. And he seemed like a very nice person. I asked him some things about himself, and he told me, and I asked him if he can meet me in a public place. So I saw him at Bayside, and I asked him to bring a resume so that I can look into it and then do background investigation.
However, just 2 weeks later, on Valentine's Day, everything took a horrifying turn. Mitchell brutally attacked Jones in their apartment. The assault left her in a coma for nearly a month and caused lasting injuries. Despite Mitchell's claim of self-defense, evidence presented in court painted a different picture. Prosecutors revealed that Mitchell had become obsessed with Jones and reacted violently when she rejected his advances. In June 2019, a jury found him guilty of attempted murder and false imprisonment. He was sentenced to life in prison that December. In 1987, Raphael Andres was convicted in connection with the death of 32-year-old Linda Azcarreta during what was described as a drug-related incident. Although he was sentenced to 9 years in prison, Andres was released after serving just 18 months due to system-related leniency. Linda's son carried the impact of that loss into adulthood.
My mother was full of life, always happy, always willing to help others when needed.
Years later, in 2005, Andres was again at the center of a serious criminal investigation. This time, the victim was 31-year-old Yvette Farinas, a well-known and beloved waitress at a local South Florida restaurant. Authorities reported that she lost her life under tragic circumstances at her apartment.
As you tightened the cord around her neck, she was aware that she was losing her ability to breathe.
Andres was later arrested and charged. In 2015, he was found guilty and sentenced to death. However, changes in state law required a unanimous jury decision for capital punishment, leading to a retrial of the sentencing phase.
You are hereby sentenced to death.
I was able to finally say something to my mom to help her after 27 years, so peace.
He was given a second chance. He destroyed it. He savagely beat to and strangled Yvette Farinas. That family will never be the same, but today they received the closure that they deserved.
In the final hearing, family members of both victims were present as the judge delivered a renewed death sentence. For many, especially Linda Azcarreta's son, it was a long-awaited moment of justice and closure. On the evening of November 1st, 2017, 26-year-old Dylann Bud Calvin Steve was at an ATM outside a bank in North Miami Beach, while his mother waited in the car. Tragically, during the transaction, Dylann was shot and killed in a robbery. His mother witnessed the incident from their vehicle, a horrifying experience that changed their lives forever. Surveillance footage captured the assailant, later identified as Marcine Hill, wearing a Kill Batman hoodie. Hill fled the scene with about $260 in cash. Hill was arrested 2 days later in Lauderhill, Florida, and charged with second-degree murder. In the courtroom, Dylann's mother addressed the judge, emotionally expressing the immense pain of losing her son.
When he took my son's life, he took mine. Nothing has been the same with him not being there for birthdays and holidays. It kills me each time. It's not fair that his mother still sees him.
A plea deal was proposed with the permission of the victim's family.
I don't want him out because I don't want him to do this to somebody else. Another mother, another parent. So him staying in prison is really no use to me.
Initially, Hill rejected a plea offer and chose to go to trial. However, in 2019, at the age of 19, Hill changed his stance and pleaded guilty to second-degree murder as part of a plea deal. Under the agreement, Hill was sentenced to 25 years in prison, followed by 10 years of probation. In March 2008, Melissa Britt Lewis, a prominent attorney and law partner at Rothstein Rosenfeld Adler, was murdered in a crime of passion by her estranged husband, Tony Villegas. Lewis was found dead.
It's not an instantaneous, ladies and gentlemen. It is a close-up type of murder. It is a hands-on, personal murder.
There was ample evidence linking Villegas to the crime.
They also notice a brown suit button. Appears to be ripped off of a suit.
Villegas' DNA was found on her jacket, and cell phone records connected him to the area where her body was discovered. Villegas had been angry over their impending divorce, and the crime was fueled by his jealousy. Though initially deemed mentally incompetent to stand trial, Villegas was later declared fit for trial after 2 forensic psychologists assessed him. His trial began over 8 years after the murder, and despite his defense offering no substantial counterarguments, the jury convicted him of first-degree murder. murder. Villegas was sentenced to life in prison without the possibility of parole, while Lewis's family finally received some measure of justice. In May 1997, 41-year-old Casey Sigler was found murdered in his South Beach apartment on Lenox Avenue. Investigators later determined he had been killed by Anthony Samson, a drifter, following a dispute over payment for a encounter. After the murder, Samson fled to North Carolina, evading justice while living under the radar. Though he eventually returned to Miami, his involvement in a series of minor crimes kept him on law enforcement's radar. For years, the case remained cold until a major break came nearly 2 decades later.
The fact is that he led 2 lives. And somewhere along the line, he allowed this individual to cross paths with him. He was a who cruised Biscayne Boulevard to pick up men.
In 2013, Miami Beach detectives matched palm prints from the original crime scene to Samson when they visited him in jail for unrelated charges. He confessed to Sigler's, bringing a long-awaited resolution to the unsolved case. In 2015, Samson stood trial and was convicted of second-degree murder.
I had never seen my dad cry before that. He told us that Uncle Casey was. We ran in the house and my mom was sobbing. I had also never seen my mom cry like that before. And I will never understand how someone can have so much evil and rage inside of them to take another person's life.
You, Mr. Samson, took a life that was good, kind, and loving.
I want to address the family first.
In a 2015 courtroom hearing, Sigler's family faced the man responsible for their loved one's. Emotions ran high as they shared painful memories and expressed their grief.
And I stand here willing to take whatever punishment, that your honor see fit.
Samson, now 50, showed remorse, claiming the murder had weighed on his conscience for years. Despite this, the judge handed down a sentence of life in prison plus 75 years. Sigler's family, while heartbroken over years of lost time, finally saw justice served after 18 long years. In July 2010, John McCluskey, along with accomplices Tracy Allen Province and Caslin May Welch, escaped from an Arizona state prison. Afterward, they targeted an Oklahoma couple, Gary and Linda Haas, who were traveling through New Mexico. The couple was carjacked, held captive, and later found dead. Following a nationwide manhunt, the trio was apprehended, with McCluskey and Welch caught in Arizona and Province in Wyoming. In 2013, McCluskey was convicted of carjacking and murder. During the sentencing phase, the prosecution highlighted his violent criminal history, while the defense argued that McCluskey's past abuse and brain abnormalities impaired his judgment. Despite these claims, the jury sentenced McCluskey to life in prison without parole, alongside additional years for other crimes. His co-defendants received their respective sentences. Province was sentenced to life without parole, and Welch received a 40-year sentence. The case concluded with justice for the victims and their families, thanks to the efforts of law enforcement agencies like the FBI and New Mexico State Police. In September 2016, Jedediah Eggy Scatliff was near Northwest 5th Avenue and 7th Street in Miami. Authorities charged Edwan Bailey with attempted murder, with Scatliff identified as the sole witness. Despite his injury, Scatliff remained hopeful, having just graduated from Booker T. Washington High School and planning to attend Tallahassee Community College. Bailey was held in custody as the case moved toward trial. However, before the case could proceed, Scatliff was fatally on June 16, 2017, while attending a wake at Williams Park in the Overtown neighborhood.
I got the call. Only thing they said was your son, Eggy, got shot. And I was shocked, like, got shot? What you mean? He got shot. You need to hurry up and get here.
His sudden death devastated his family and community.
At this point, I would argue there is no evidence. There's even less nexus in terms of no DNA has been found as of yet on any items collected.
In court, Bailey's defense attorney argued that without the living testimony of the only witness and no physical evidence like DNA linking Bailey to the crime, the charges should be dropped. A new hearing is expected to determine whether the case will be dismissed. In early 2015, Marc Wabafiyebazu from Ottawa moved to Miami with his older brother Jean to live with their mother, Roxanne Dubé, who had recently been appointed Canada's Consul General in Florida. On March 30th, the brothers used their mother's diplomatic vehicle to visit a Miami apartment for a marijuana deal. What began as a transaction quickly turned deadly when fire erupted inside the apartment, Jean and local Joshua Wright. Marc was found outside the apartment and was arrested shortly after. Although he did not fire any shots, Florida's felony murder law allowed prosecutors to charge him with murder because of his alleged role in the attempted drug deal that led to the deaths. Marc was charged as an adult and pleaded not guilty.
We have entered a plea of not guilty to these charges. We look forward to our day in court, and we have a confidence in the criminal justice system.
His mother attended the arraignment, showing quiet support during an emotional courtroom moment.
Our heart goes out to all the families. This is a tragedy, but now we're here, and we are going to be defending these charges.
Marc's lawyer argued that the grand jury erred in its decision, stressing Marc's lack of direct involvement and his young age. The defense also requested an Arthur hearing, hoping Marc would be allowed to await trial at home. His legal team remained optimistic despite the international media attention and the tragic circumstances. Ultimately, in 2016, Marc entered a no-contest plea to reduce charges and was given a conditional sentence, bringing an end to the widely publicized case. In February 1974, 21-year-old Eileen Farrow, a dental assistant, was found dead inside her home on Lady Slipper Lane in Shrewsbury, Massachusetts. Her husband discovered her body and immediately alerted authorities. Investigators noted no signs of forced entry, suggesting the victim may have known her attacker. One name that surfaced early on was Lonzo Guthrie Jr., a furniture delivery man who had visited the Farrow residence just 2 days earlier to deliver items.
He was a truck driver and over the road, a long-haul driver, which means that he spent a lot of time moving around in different states.
At the time, Guthrie was questioned but not charged due to a lack of conclusive evidence. The case eventually went cold. Decades later, a breakthrough came when Guthrie's DNA entered into a database following a probation violation in California, matched blood evidence from the 1974 crime scene. He was arrested and brought back to Massachusetts to stand trial.
Do you wish to waive your rights and return to Massachusetts, or do you wish to stay in custody here in Douglas County?
Prosecutors argued that he had returned to the home and committed the crime. Guthrie, however, claimed the blood found at the scene came from a minor injury he sustained during the original furniture delivery. In 2016, after a lengthy trial, a jury found Guthrie not guilty, bringing the case to a close but leaving many questions unanswered. Teresa Balboa's involvement in the tragic death of Samuel Olsen began in May 2021 when Samuel's father, Dalton Olsen, reported his son missing. Balboa, who was living with Samuel and his father, claimed that Samuel had been taken by a police officer during a custody dispute. However, this story quickly fell apart as investigators uncovered key evidence that contradicted Balboa's account. Surveillance footage from the day Samuel was supposedly taken showed that Samuel's biological mother was at her own residence, not involved in the alleged abduction, as Balboa had claimed. Further investigation revealed the horrifying truth. Samuel had already been dead for weeks before his disappearance was reported. Balboa's involvement in covering up the crime was uncovered when her roommate, Benjamin Rivera, came forward with disturbing details. Rivera told authorities that on May 10th, Balboa contacted him and said Samuel was dead. He went to their residence, where he noticed bruising on Samuel's body. Together, they placed the boy's body in a bathtub, where it remained for 2 days. They then wrapped it and stored it in a storage unit in Webster, Texas. On June 1st, 2021, authorities received an anonymous Crime Stoppers tip, leading them to a motel in Jasper, Texas. There, they found Samuel's wrapped in a black, as Rivera had described. Balboa was arrested at the scene and charged with tampering with evidence, specifically with a human corpse.
I'm urging the state's motion requesting a $500,000 bond, and I am opposed to a personal bond. The facts set forth in this warrant are terribly disturbing. Specifically, this year-old complainant's father had reported his son missing after he had been in the custody of this defendant. This defendant was interviewed, told the police that the complainant's biological mother and an unidentified individual that she claimed represented himself as a police officer had taken custody of the complainant from her residence or from a residence in Harris County without consent. An employee from the complainant's school advised that the complainant was last at school on April 30th, 2021, which is when which is a month prior to when this defendant claimed that the complainant's mother had taken non-consensual custody of him. That defendant's statements were refuted by the surveillance footage provided by the complainant's mother, showing her at her own residence at the time the defendant claimed that she had come and taken custody of this complaining witness. The complainant's father told officers that the defendant told him on May 27th that the mother had come and taken custody. All of which was refuted by that surveillance video. Another individual who is this defendant's roommate told officers that he had seen the complainant at a residence on the Gulf Freeway on May 27th, 2021, along with this defendant and this defendant's mother, and that on May 10th, he stated he was contacted by the defendant who advised him that the complainant was deceased, that he did observe bruising to the complainant's body when he arrived to that address on the Gulf Freeway, and that he and this defendant had placed the complainant's in a bathtub where it remained for 2 days, that he had purchased duct tape and a plastic tote at a local Walmart on the 13th, which was verified by a receipt that was recovered, and that he and this defendant had wrapped the complainant's in a plastic sheet, placed it into the tote, and took it to a storage unit located in Webster, Harris County, Texas. On June 1st, the Jasper Police Department received a Crime Stoppers tip about the complainant in this case. They went to a motel located in Jasper County where they found this defendant. They found the tote that was described by the witness. They smelled the distinct odor of decomposition, human decomposition, in the motel room, and they did find what they believed to be the complainant's wrapped in a black plastic bag, which was secured with duct tape as described by the witness. They also spoke to another witness who stated that this defendant had asked him to come and pick her up. He met her in Cleveland, Texas, where they drove then to Webster and obtained the tote from the storage unit. He took her and dropped her off at the motel, and then he is the one who reported the Crime Stoppers tip. Based on the fact that she was found in Jasper County with other information that was en route to Louisiana per the statements in the motion, the fact that there is ongoing investigation as to the complainant's cause and manner of death, and that additional charges may be filed once that investigation is complete. We are asking for that amount, also based on the fact that she's currently on bond for a felony domestic violence charge against this minor complainant's biological father, who is the one who had reported him missing. I don't have any reason to believe that a personal bond or a lower bond will be reasonable or sufficient to ensure public safety
In court, Balboa's bond was set at $500,000 as the prosecutor requested, later increased to $600,000. Later, Balboa entered into a plea deal, pleading guilty to first-degree murder. In exchange for her guilty plea, she was spared the death penalty and sentenced to 52 years in prison with the possibility of parole after 26 years. On the rainy evening of Saturday, March 27, 2021, a tragic incident unfolded on Highway 24 near Lakewood Lane in Anderson County, South Carolina. 19-year-old Josephine "Josie" Nunn, a former Pendleton High School cheerleader and med tech at Dominion Senior Living, was driving home in separate vehicles alongside her boyfriend, Ryan Gambrell. As they traveled down the poorly lit and slick highway, a black Dodge truck approached and maneuvered sharply near their vehicles. According to Ryan, the truck veered in a way that caused Josie's car to collide with the roadside barriers. Despite wearing her seatbelt, Josie the scene. In the aftermath, the Anderson County Sheriff's Office launched an investigation. They released an image of the suspected vehicle, a 2009 to 2019 black Dodge four-door truck with silver trim, and offered a $1,500 reward for information. The case gained attention across the community, with friends, family, and the public pleading for justice. Several days later, 40-year-old Albert R. Phillips of Westminster came forward through his attorney, Beatty Ashmore. Phillips voluntarily turned himself in, waived his rights, gave a full statement to investigators, and allowed authorities to search his home and seize his truck.
Sir, you're being charged with hit and run, duties of driver involved in an accident with, and this carries not less than 1 year in jail, nor more than 25 years, and a fine of not less than $10,000, nor more than $25,000.
He was officially charged with hit and run involving a serious felony that carries a penalty of 1 to 25 years in prison and fines between $10,000 and $25,000. Phillips claimed he didn't make direct contact with Josie's vehicle. According to his lawyer, the crash happened during heavy rain on a poorly maintained road, and both vehicles swerved at the same time. He also mentioned that Josie may have been driving at a high speed and said data from her car's black box was being reviewed. A bond hearing was held shortly after his arrest. Inside the courtroom, emotions ran high. Phillips appeared alongside his lawyer and family, while Josie's loved ones, including her boyfriend and family attorney Christopher Pratt, sat quietly across the aisle. Attorney Ashmore described Phillips as a father of three with steady employment and no criminal history.
With me this morning are his mother and grandmother. There are a number of family members here. Judge, it's a tragedy. It's just a terrible, terrible case. We're all sorry to be here this morning. But Judge, my client, the emotions are high, but the facts are this. My client on Sunday came to me. We agreed immediately that he should turn himself in. He always wanted to do that. It took me a couple of days to talk to the solicitor's office and law enforcement, and we got an interview arranged for that Tuesday. He's been completely cooperative. He gave them a statement, waived his Miranda rights. They seized his truck. They searched his home. And Judge, the facts are difficult. The investigation is ongoing. But what he told law enforcement was that he did not make contact with this young lady's vehicle. And that just remains to be seen. It was at night, it was in the rain, it was a road under construction, and a really difficult circumstance for all involved. So again, the investigation is ongoing. What he did tell law enforcement is that the young lady had come up after he had passed these two cars. The young lady came up from behind him at a high rate of speed, and they both swerved at the same time. Law enforcement confirms that apparently she was driving fast that night. Her black box from the car has been taken. They couldn't analyze it here, so they sent it down to Columbia for analysis, and we're waiting on that, Your Honor. So all that being said, Judge, we're so sorry to be here today. I'm directing him not to speak. He wants to say how sorry he is to have any involvement in this at all, but under the circumstances and the emotions are so very high, Your Honor, I'm asking him not to speak. Judge, he's not a flight risk, he's not a danger to the community, and those are the two standards, of course, that you use every time you set a bond, and I'm asking you to do so this morning and set a reasonable bond that he can make and hopefully make bond, post bond, and he was at church last Sunday. He wants to be at church tomorrow, Easter Sunday, with his family, like he was last Sunday. So, Your Honor, if there's nothing further, that is my request.
Does he work? Is he employed?
He's been employed, gainfully employed for as long as I just for a number of years, Your Honor.
Okay.
I'm not certain how long. Yes, he's got a good, solid job.
Okay.
He asked the judge to consider his client's cooperation and remorse, stating that Phillips was not a flight risk or danger to the community. However, the victim's family expressed deep pain and frustration.
I'm proud I represent the Nunn family, and you know, Your Honor, as Mr. Ashmore said, and he's right about this, is that this is just an awful tragedy, and the pain is just probably more than these folks can bear right now. You know, we obviously have some very, very serious questions. We don't understand why Mr. Phillips left the scene, despite whatever may have happened before this. And the investigation is ongoing. These folks just want answers, and they want justice for their daughter. And so that's what they would ask this court to give, and we would just ask for that.
Okay.
Christopher Pratt questioned why Phillips left the scene if he truly believed it wasn't his fault. Josie's mother gave emotional testimony, asking how someone could leave her daughter behind without calling for help. Through tears, she described the heartbreaking reality of losing a daughter so young and the lasting pain it had brought to their family.
All right, Mr. Phillips, of course, I don't want you to have any contact with the victim's family. No contact in any way. You understand that?
Yes, ma'am.
Okay. I'm going to set your bond at a $30,000 surety bond, which means you'll have to go through a bail's bondsman or put up property to make your bond. The officer can give you a list down there if you need it. We do.
Judge Malone set bond at $30,000 and ordered Phillips to have no contact with the Nunn family. Meanwhile, a memorial stood at the crash site, decorated with balloons, flowers, and messages of love, and served as a quiet tribute to a young woman gone too soon. Josie's family continues to grieve, holding on to memories while seeking justice in her name. It was Thanksgiving night in 2020 when a quiet road in Anderson County, South Carolina, became the site of a tragic accident. 18-year-old Justin Fowler was behind the wheel of a pickup truck traveling along Lake Road near Riley Road. At some point during the drive, the vehicle veered off the right side of the road and struck both a fence and a tree. Fowler, who was not wearing a seatbelt, walked away from the crash without physical injury. However, his front seat passenger, 21-year-old Charlton Pierce Williams from Easley, was critically hurt. Emergency responders had to remove Williams from the wreckage before rushing him to Prisma Health in Greenville. Sadly, despite medical efforts, he passed away during surgery. A backseat passenger was also hurt in the crash, though details about their condition were not released. In the days that followed, the South Carolina Highway Patrol launched an investigation.
Sir, you're being charged with felony driving under the influence, where results. And this charge carries a mandatory fine of not less than $10,100, nor more than $25,100, and mandatory imprisonment, not less than 1 year, nor more than 25 years. You're also being charged with felony driving under the influence where great bodily injury results. And this charge carries a mandatory fine of not less than $5,100, nor more than $10,100, and mandatory imprisonment for not less than 30 days, nor more than 15 years. Both of these go to General Sessions Court, okay? And I know you've never been in trouble before, is that correct?
Fowler was charged with felony DUI resulting in and felony DUI resulting in great bodily injury, both serious charges under South Carolina law. At a bond hearing in Anderson County, the judge explained Fowler's legal rights, including his right to an attorney and a jury trial.
And the victims in this case, y'all were friends. Is that right? Okay. Mr. Fowler, I'm going to set your bond on these charges at a $30,000 surety bond, which means you'll have to go through a bail bondsman or put up property to make your bond. I know your family has talked to a bondsman. I don't know if you're going to get out tonight. I'll let you know. Okay? Do you have any questions about anything?
No.
Okay. You're going to have to sign for your paperwork. The officer's going to tell you when to sign and initial. And then you're going to get a copy of everything you sign. It's just basically what I went over, and you'll get a copy of everything you sign. Okay?
Okay. Just fine.
Do y'all have any questions?
No, I don't think so. They're just devastated.
I know.
We got a few of them, okay?
We're praying for all the families.
He's really a great kid.
I know.
His motivation.
Gina, you gonna talk to him, or are you gonna do the bond, or do you know? Okay. All right. Mr. Fowler, you're gonna, the bondsman is going to do your bond tonight, so you will be getting released this evening. It'll be several hours before you're released. You will be able to use a phone to call your parents to pick you up. Okay? All right.
A $30,000 bond was set, and he was given instructions on how to request a public defender if needed. Since then, there have been no significant public updates on the legal proceedings. On the evening of November 14, 2023, a tragic incident unfolded in Anderson County, South Carolina, during a routine custody exchange between 34-year-old Adam Hanna and his former partner. The exchange, intended to be a peaceful handover of their twins, quickly escalated when 29-year-old John Chadwick Stevens arrived at the residence. An argument broke out between Hanna and Stevens, which turned violent when Hanna pulled out a gun and Stevens. Deputies responded to the scene around 8:30 p.m. and found Stevens from a wound. The Anderson County Coroner's Office later ruled his death a homicide.
At this time, you have a charge for domestic violence of a high and aggravated nature. It does carry up to 20 years in jail if you plead guilty or if you're found guilty.
Hanna was initially charged with criminal domestic violence of a high and aggravated nature. The following day, authorities added more charges, including murder and possession of a weapon during a violent crime. During his bond hearing, Hanna expressed remorse, stating, "I'm sorry for everything." Judge White, who presided over the hearing, imposed strict conditions, including a no-contact order with the victim's family and a ban on Hanna returning to the scene of the incident.
Mr. Hanna, this hearing is being recorded. It can be used later against you in court. Do you have any statements you want to make to the court or anything you want me to know at this time?
I'm sorry for everything. I'm sorry. I didn't mean for any of this.
Okay.
I've never put a hand on Shelby. I've never touched her. I'm sorry. I didn't want this to happen.
At this time, there are going to be some bond conditions. If the victim decides to enter a domestic violence shelter and you follow her there for any reason, you can face additional fines and penalties. There will be a no contact order with the victim, including returning to the residence until this case is disposed of. Do you understand those bond conditions?
Yes.
Okay. Based on this charge, as well as charges that are pending, your bond will be denied tonight. You'll have an opportunity for a circuit court judge at a later date, at which time they'll determine the appropriateness of bond. Any questions?
So I can't, there's no getting out?
Not at this moment, no. Your bond's been denied, and you'll have some other charges that we'll see you on tomorrow. But with all the circumstances surrounding this, your bond on this charge is going to be denied.
So it's all going to be decided tomorrow?
No, I'll see you again in the morning. I'm the bond judge in the morning. We'll go through those charges at that time. And then at a later date, because your bond's been denied on this one, you'll see a circuit court judge who will determine at that point whether bond's appropriate under certain conditions, okay? So you'll be held here until that time.
Given the severity of the charges, bond was denied, and Hannah was remanded to custody. He was informed that he would face a circuit court judge for further proceedings. The community was left in shock over the loss of John Chadwick Stevens, remembered fondly as a kind-hearted individual. His death has been commemorated on the National Violence Memorial. As the investigation continues, authorities are working to gather more information regarding the incident. On the night of June 22, 2013, a female Vanderbilt University student went out drinking with her boyfriend, Brandon Vandenberg, a wide receiver on the university's football team. She became severely intoxicated. By the early hours of June 23rd, she was unconscious. Security footage from campus later revealed that Vandenberg, along with 3 of his teammates, Corey Beatty, Brandon Banks, and Jaborian Tip McKenzie, carried the unconscious woman into Vandenberg's dorm room at Gillette House. Inside the room, the situation took a dark turn. While the woman remained unconscious, the 4 young men took photos and videos of her in a vulnerable state. According to prosecutors, the footage and photos later recovered by forensic investigators depicted inappropriate and invasive acts. Vandenberg was accused of encouraging the others and distributing items used during the assault. He also attempted to delete the evidence afterward. Within a few days, Vanderbilt University learned of the situation and acted swiftly. On June 29, 2013, the 4 players were dismissed from the football team and barred from campus while a criminal investigation began. After weeks of investigation, all 4 were arrested on August 9, 2013. Each was indicted on multiple counts, including aggravated and battery. The disturbing digital evidence recovered from their phones became a key component in the case. In January 2015, the trial for Brandon Vandenberg and Corey Beatty began. The case captured national media attention and ignited widespread conversations about college culture, consent, and accountability. During closing arguments, defense attorney Fletcher Long addressed the jury for 33 minutes.
They want you to believe there's all these acts of that are not shown in a photograph or in a video. They want you to believe that perhaps there's some 29 other minutes of video they just weren't able to retrieve. And perhaps some of that video might have shown you acts of that they have charged, but for which they really don't have any proof. You know, she had a medical legal exam done. She didn't have any incidents of trauma vaginally, didn't have any incidents of trauma anally. Reported to the police that she didn't believe she had even had sex. Didn't think she had been assaulted, was her initial report. Turned down the first MLE. Now this in and of itself, you may say, well, you know, there's a video. Okay, there is a video. But I told you in opening statement that you were going to have to differentiate as this case was tried, the difference between what you see and what you're told, and who told you. So the government's theory is that perhaps there's this other video that would have shown these other acts of you don't see. Well, that, you know, again, you come back to your common sense. I mean, if someone's videoing what you're seeing, why did they draw the line at the other stuff? Well, they wouldn't have. You know, if the purpose of this is gratification of some nature, the stuff that the government's telling you they didn't video would have been substantially more gratifying than what they alleged, than what they did. Yeah. So, Mr. Vandenberg says squeeze that shit 3 times, and here he is, facing 5 counts of aggravated criminal responsibility for aggravated. In the first 4 counts, the primary actor takes the stand, mans up, and says, I did it. I don't remember it. I did it. If it was done, I was drunk, but it wasn't Mr. Vandenberg who made me do anything. I wasn't acting under any of his direction. I wasn't solicited by him. He didn't aid me. He didn't attempt to aid me.
He didn't say that, Your Honor, because he had no memory of it. I objected.
I asked him on cross. He most certainly did. I asked him those questions on cross-examination. So, in that first 4 counts, I mean, you know, how's the government overcome that with perhaps. How can they overcome that? Then in counts 5 and 6, they've got Banks. Y'all remember Banks? Banks is Mr. 14. 13 pictures introduced in this trial, 14 of them from Banks or Banks' phone. Mr. McKenzie owns up that he took some of them. Mr. 14 didn't testify. We don't know who was directing. But we know this from Mr. Beatty's testimony, this big meeting at Popeyes that the government wanted to tell you about, where they claimed there was some meeting to cover up or whatever. Mr. Vandenberg wasn't even there. He wasn't even at Popeyes. So you see, somebody in this case has got to delineate a difference, and there is a difference between the head man and the odd man out. In count 9, we're charged with illegal photography. And that's what we did. We did that. He took photographs that he never should have taken. He exercised judgment that was deplorable. He at least had the sense in the aftermath to be upset by it. Judging from the photograph of him going through, being consoled by Dylann Vanderwall, he went around and tried to get these pictures erased. You know, he at least had the sense to be upset about it. There are 4 words above the door at the United States Supreme Court House. 4 words. Equal justice under law. That is the hope and aspiration of all of criminal jurisprudence. Equal justice under law. Lady Justice is blind. She doesn't see money. She doesn't see race. She doesn't see position. We should all be permitted and admitted to equal justice, the concept of equal justice. Now, there's a famous attorney down in Dixon named Mitch Dugan. Fantastic trial lawyer. Fantastic rapport with juries. And he likes to say in jury trials, I don't care what the law is, what they're doing to this boy ain't right. I'm not telling you that. I care what the law is, and they haven't met it. But I will tell you the second. What they're doing to this boy ain't right. He can be found guilty of illegal photography. That is what he did. Return that verdict. He isn't any more responsible for the conduct of other actors than anybody else is. What he said that night wasn't sufficient to direct, solicit, aid, or attempt to aid anybody. The comment he made regarding the bottle was stated after the commission of the offense, if there was at all. And the person that allegedly was directed, solicited, aided, or attempted to be aided, you haven't heard from. His name is Banks, and he wasn't here. The government gets another opportunity to address you. This is our last chance. Equal justice under law.
He acknowledged that Vandenberg showed extremely poor judgment by recording the incident, but insisted that his client didn't physically participate in the assault. He argued that there was no direct evidence proving Vandenberg committed the act himself, though he admitted his involvement in unlawful photography and efforts to erase the evidence. Despite this defense, the jury found Vandenberg and Beatty guilty. Vandenberg was convicted on multiple counts, including aggravated and unlawful photography, while Beatty was found guilty of participating in the assault. In July 2016, Beatty was sentenced to 15 years in prison. During Vandenberg's sentencing, the prosecution emphasized that the emotional and psychological harm inflicted on the unconscious victim far exceeded physical injury.
The state has submitted a letter from her counselor at Vanderbilt who described the traumatic emotional impact that the had on the victim in the months following this attack. Additionally, the state submitted a letter and CV from the victim's clinical psychologist. And she describes specifically that a victim who is while unconscious suffers from a more complex trauma than other victims because a person's body still has memory of that trauma. She further details the severe emotional effects on this victim that are those of post-traumatic stress disorder. And she details that she believes that she will need continued therapy and support for a very long time. Another professor at Vanderbilt submitted a letter to Your Honor who compared the person she knew before this to the one now as a person who was totally broken. The state also submits that the factor that this act was committed to gratify the defendant's desire for pleasure or excitement, that factor applies as to counts 1 through 5 and 8. The motivation for can be something other than pleasure. It can be motivated by acts of brutality, revenge, punishment, or intimidation.
She cited expert testimony diagnosing her with PTSD and noting she would require long-term therapy. A professor described her as completely broken after the assault.
The court does believe that the defendant is in a position of private trust. Moreover, the court believes that the defendant was a leader in this particular offense. But for him, it would not have happened. And in particular, the court believes that he is the one who could have stopped this incident that destroyed so many lives here. In any event, the court also finds with respect to mitigating factors that there are several, that the defendant did not have any prior criminal convictions, and the defendant has a lot of family and community support. And he may be remorseful, it seems remorseful at least, but even having said that, the court believes that the enhancement factors outweigh the mitigating factors in this particular case. As such, with regard to counts 1 through 5, the court believes that the proper sentence is 17 years. With regard to counts 6 and 7, 9 years. In regard to count 8, 2 years, all of which will run concurrently with one another for a total effective sentence of 17 years.
In November 2016, Vandenberg received a 17-year sentence. Both men were also required to register as offenders for life. The remaining 2 players face separate legal proceedings. Brandon Banks was convicted in June 2017 and received a 15-year sentence. Jaborian McKenzie, who had cooperated with prosecutors and testified during the trial, accepted a plea deal in May 2018, receiving 10 years of probation and lifetime offender registration. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.